Wendy.
And we'll start the recording now.
Yeah, I just heard that. Thanks, Wendy. I appreciate that. Okay. As you are aware, our guest is Judge Brassington, and she's going to give us a talk, and then we'll also have a Q&A after that. Judge Brassington is a graduate of the University of Queensland Bachelor of Laws in 1990, who was admitted as a barrister to the Supreme Court of Queensland in 1992. Prior to her appointment as a magistrate, Her Honour worked with the Office of the Director of Public Prosecutions and with the Department of Justice and Attorney General. Her Honour was appointed as Magistrate of the Magistrates Court of Queensland in 2005 and has served in Southport, Innisfail, and as the Regional Coordinating Magistrate in Cairns. In 2019, Chief Magistrate Judge Brassington was appointed Deputy Chief Magistrate in Brisbane, fulfilling the role of Brisbane Coordinator until 2021, where Her Honour served as the Regional Coordinator of Queensland for a year before returning to the role of Brisbane Coordinator in 2022. In 2022, Her Honour was appointed as a Judge in the District Court of Queensland and the Chief Magistrate of Queensland. Judge, welcome to the Connect program, and I'll hand over to you to talk to our members, please.
Thank you, Brooke. Well, good evening, everyone. And I'd like to thank your president for inviting me to speak to you about the work of Justices of the Peace and Commissioners of Declarations in both witnessing documents and how that works with Magistrates Court, what potential issues there are, and how and supporting the courts. I'll address each of those topics separately, but I also want to touch on the recent amendments to the Oaths Act. I'm going to also begin by acknowledging the traditional custodians of the lands where I am and we meet today, and pay my respects to the elders past, present, and emerging. Firstly, I'd like to thank all of you for the work that you do. The services provided by Justices of the Peace and Commissioners of Declaration really do play an integral role in supporting the work of the courts. And it's really an invaluable service for the Magistrates Court. Your services do not go unnoticed. And I have worked in regional courts in particular when I was at Innisfail, and that the volunteers who turned up every day and to assist the community and also the courts by relieving particularly, and this is the case in regional courts, but also in the Brisbane Magistrates Court, the registry of significant amount of work in witnessing documents, issuing warrants, summonses, witnessing statutory declarations and affidavits, and that really takes pressure off the registry staff and allows them to support the court. I know the regional, and I asked the regional director of Brisbane, who said to me that the voluntary Justice of the Peace, Commissioner of Declarations, make the registry staff workload much more manageable. And without the voluntary justices, the court registry staff would have to sign all the bails and all the warrants, and it really would increase the workload of the staff in a place like Brisbane by at least 2 court staff per day. And also the invaluable work of Justices of Peace in the community program, which allows people to access their services in places that are not courts. I'm well aware many of you are very experienced and have been Justices of the Peace and Commissioner of Declarations for many years. So this part of the talk where I'm going to is really directed perhaps more to those who are new to their roles and without probably that level of experience. And it was really looking at the potential issues that can arise and to be aware of them and keep them in mind. The first is accuracy to what we're doing. It's important when receiving documents, and I'm talking here about complaints that you may receive or applications from police for search warrants, but also statutory declarations, that any alterations are initialed and to check that the format is correct. I've seen and have, in fact, printed out the new statutory declaration forms, which are quite voluminous, and they're quite different, in fact, from the civil statutory declarations that we're all familiar with. And that it's important to remember that those simple declaration forms are still valid and perhaps for people easier to understand. And it's only when embarking on witnessing substitute signatories and indeed by audio-visual links for special witnesses that sometimes those complex forms are actually necessary. I know that many of you working both in the community but also in the courts are seen as people who can provide to others legal advice. And the simple answer is you shouldn't provide it. It's really difficult. And I know from being a magistrate, many people will ask me, how do I do that? What is, my options for legal advice? And I say the same thing, that I, being a judge or a magistrate, can't actually advise you about what you have to do. You really need to take your own legal advice from private firms or community legal centres. The range of legislation you will deal with is vast. No one can know all of the various legislative schemes, and it's also very difficult because of the ongoing amendments to what type of documents you will be amending. So it's important to ask, and particularly with respect to those matters, often police officers, the legislation that they are relying upon to seek the particularly warrants or other documents that you will be witnessing. The general advice we give, and often we have new magistrates as well who are very used to, in fact, witnessing documents in the way that they may have to, doing out of hours work, that you really need to ensure that the person signing understands what they're signing. And you're no doubt aware that the Oaths Act now has requirements when witnessing affidavits or declarations to take reasonable steps, both to identify the signatory, the name of the signatory, that it matches the name of the signatory written on the affidavit or declaration, and also dates are important to check that the dates that witnesses which you're signing, the dates that you are entering are correct. One of the common, and it can be a challenge on a face of a warrant, is that the date is actually not correct. And that has implications to the time of the warrant and all sorts of flows from the simple error in a date. The I know the JP branch and indeed the association has an e-log book which allows both a useful checklist when witnessing documents and also maintaining your own records as to what you're actually witnessing and when and the date. and simply a book can make verification in circumstances where someone is denying signing or the date it was made much easier for everyone. The most of you will deal with applications for search warrants under the Police Powers and Responsibilities Act, under Section 150. There are certain orders that can't be made by justices of peace. There will be orders to search now telephones and other devices of that sort. They must be made by a magistrate, but most other search warrants can be done by the justice. And it's always important to remember that you as can ask for further information from the applicant if you're not satisfied with the material before you. And indeed, if I'm doing a search warrant and the applicant's there, and depending on the urgency of the matter, and there is further information that I take into account, then I will have the applicant write on the back of the grounds for the search warrant to the new further information that they're telling me, and have them initial it and have them sworn again. That way, there's a complete record of the grounds that you are having regard to in determining that there's reasonable suspicion. Because the most common challenge, indeed, in the courts from to search warrants is whether suspicion is held on reasonable grounds. And so with that documentation, can be review of the grounds that were actually taken into account. All of you will recall the COVID public health emergency. And those of you who were Justice of the Peace and Commissioner of Declarations at the time will indeed remember the range of temporary legislative measures that were put in place to try and ensure that business could go on and while still protecting the health of people. And out of that was a much greater use of courts by digital technology and the introduction of emergency legislation. And that many of what occurred in that emergency legislation has now found itself into the Oaths Act and other acts by the Justice and Other Legislation Amendment Act. And that commenced by proclamation on the 30th of April, 2022. And without any criticism of the drafters, I think we all could agree that many of those amendments are quite complex. And certainly in considering them myself and utilising them, I find it impossible to do it without reference to the legislation with me. The easy ready reckoner for it, that whole legislative scheme, is that anything you have to witness over audio-visual link has to be done by a special witness and or another person prescribed by regulation. And the Act provides for the definition of a special witness, which includes legal practitioners, government legal officers, and relevantly, justices of peace or commissioners of declarations who have been approved by the Chief Executive of the Department of Justice and Attorney General. The reasons, it appears, for this category of special witness is that it was perceived that over audio-visual link, the risk of fraud was higher and the risk of undue influence, and it was determined that having a smaller cohort, it appears, to assess both the capacity and the risk of undue influence has led to the creation of the special witness category. I'm informed that there are 28 special witnesses across the state who've undertaken training with the Justice of the Peace branch, and indeed I understand 2 former presidents and presidents of the Justice Association are indeed special witnesses. If you're in the physical presence, and I mean the presence of a witness, then the justices, and depending on the type of documentation, the Commissioner of Declarations can witness those documents. So that particular scheme is largely unchanged, and which is where I referred with respect to the statutory declaration and the new forms. They're allowing, it appears, the crossing out of the, if you like, irrelevant signing areas, so that, for example, if it's one that there's no substitute signatory, then that can be simply crossed out and in those circumstances initialed, leaving the simpliciter declaration. So there's the new form requires that attention to what should be deleted from the statutory declaration, which is why, and I consulted with the JP branch, that they were still encouraging the use of the simple statutory declaration form. But I should note, in the most recent legislative amendments, and these were done in as part of the Domestic and Family Violence Protection, Combating Coercive Control and Other legislation, inserted a new section 13F in the Oaths Act, which really looks at minor non-compliance and meaning that minor non-compliance does not affect the validity of an affidavit or declaration. What really seems to be focusing on is, it says that the affidavit or declaration is not invalid only because it doesn't comply with the requirement under sections of the Oaths Act, as long as it doesn't materially affect the nature of the affidavit or declaration, and indeed court's power to admit an affidavit, including a purported affidavit under section 31G, as evidence in a proceeding. So that, to a certain extent, has simplified some of the significant complexities of the new amendments, which had required, if certain sections were not completed or placed some doubt as to the validity of the actual affidavit. And I think that particular section has provided some leeway in ensuring that minor technicalities will not interfere with the admission of the affidavit or declaration. The as I said, the provisions are significant, can be significantly complex. I think they have obviously tried to address some of the degree of the complexity by the annexures to the statutory declaration form that the acts as indeed a guide going through completing the page of how the document was made, to capture those matters and to explain how which witnesses can interview the particular can complete a particular document. To give some idea of the complexity of the scheme, we had quite a number of discussions because of the definition of special witnesses in the Oaths Act, where in fact, whether judicial officers were indeed special witnesses, because we're justices of the peace by virtue of the Justice of the Peace and Commissioner of Declarations Act by force of law. However, obviously, we're not people approved by the by the CEO, and we're people who, because of not having practicing certificates, may not be Australian legal practitioners because we're judicial officers. But that too has been recently clarified, perhaps, in amending legislation. The courts, as I said, have adopted the use of the audio-visual technology to ensure that witnesses, particularly those in remote locations and confronted by what occurred in the COVID pandemic, are not disenfranchised from pursuing their legal rights. And we have had particular success, perhaps is one way of putting it, by the utilising such technology in the domestic and family violence jurisdiction. Many of you will have witnessed private applications. That can now be done. The application can now still be filed without that witness in court, and the applicant can, in fact, verify and over the audio-visual link to the magistrate in court. And that has given us much greater flexibility of ensuring, particularly aggrieved people can be in a remote location, which is often safer in those circumstances, and still verify the application before the magistrate in court. How the amendments to the Oaths Act are working in practice, it'd be interesting. As I said, I think your experience is probably going to be greater than the courts at this time. We have yet to receive any particular challenges to the various amendments. As I said, there had been some minor defects, and they have been essentially remedied by the amendments in the Domestic and Family Violence Protection Amendment Act. So it'd be interesting to hear your experiences with both the forms renewed and the complexity of the scheme, whether there's any particular changes that may well be useful. So I've spoken to Brooke earlier, and I said perhaps it would be easier if I also took questions from him and others to clarify any issues that I can. Brooke.
Yeah, thank you, Judge. Yes, I do have a few questions. And these are drilling down to the witnessing level rather than the administrative level. But are you able to share any observations about the quality or otherwise of the witness documents that are tendered in court proceedings?
Well, I can say that, the huge majority are witnessed according to law. There are very few challenges to the documentation that the court sees. Very few. For the numbers that go through, it's extraordinarily low. I have had experience, and again, it's the different legislative schemes just to be aware of, where certain types of documents, and many of you will be aware of the Peace and Good Behaviour Act legislation, where a complaint can be made to a Justice of the Peace, and that begins, in fact, the issue of the summons, and that begins the application for a Peace and Good Behaviour order. There have been cases where, upon reviewing the actual complaint, it was witnessed by a Commissioner of Declarations, which then, because of the non-compliance with the section, had to be struck out, and essentially the person has to start again. So it really emphasises when witnessing, if it's a document that you're not used to seeing, it's important to check the power to actually do it.
Thank you. And I guess you might have already answered this question, but are there any documents challenged by defence lawyers, solicitors, regarding the witnessing procedure? And again, I'm going down to the actual practice of it, the document that the JP or the CX is witnessing.
Yeah. Not one of them is, it's more common for the witness, not so much a challenge to what the JP witnessed, but more that the witness, the person who supplied perhaps the affidavit, may deny making it or deny signing it, which is a difficult issue, because I don't think anyone expects a Justice of the Peace or Commissioner of Declaration, or indeed a magistrate, who may witness thousands of documents, to be able to often to identify the person. But that's where the issue of the logbook and a record is really comes into is a significant issue. Yeah.
Thank you. So another one, and I'll go back down to but affidavits. What happens with an affidavit that's not witnessed correctly? And I've got a couple of examples. For example, where it might have sworn at the outset and affirmed in the jurat. What would that cause any challenges or bring any challenges forward, or would the affidavit be thrown out because it's incorrectly done?
You mean if the person swears at the beginning?
Yes.
And then affirms at the end?
This is the JP or the CDEC. So they're either going to cross out sworn or affirmed at the beginning and cross out sworn or affirmed at the end.
Yeah.
But they make a mistake and they do sworn at the beginning and don't cross out affirmed at the end. So it's incorrect, if you like, at the jurat.
Where it's going to have an impact, I suspect, if in a court proceeding, it may not. The court may, utilise the minor discrepancy. But where it will have an impact is if you're witnessing, say, enduring powers of attorney or powers of attorney and some of those documents, because the error may cause a person who's seeking to rely on it not to rely upon it. And that's where I see those issues, that if I was looking and seeking, someone relying on enduring power of attorney, a power of attorney, or even advance health direct, some of these documents, taking that document then, say, to a bank or those matters, the bank may well say, no, we are not relying on that document because of that error upon the face of it. And I think that I think that would be the correct choice from the bank's perspective or someone who's looking at it, because if they then proceeded to rely upon it, they would be liable. So I see those issues may well largely be relied upon to if you're seeking to rely upon that document. The other example I can think of is often you get sworn declarations in traffic matters, where someone is, I'm not the driver, those sort of documents, swearing affidavits to that effect. And again, if there's an error on the face of it, particularly the issues as affirming and swearing, it would certainly cause me to hesitate to rely upon it, because arguably there's going to be no remedy for that being a false document.
Sure.
Yeah, no penalty.
But you do have discretion if you want.
Yeah, in the court, a minor, as I said, if it doesn't go, but there is now, if it doesn't go to the veracity of the affidavit material.
Sure. And I've just got one more. Are JPs or CDECs ever called to court to give evidence about the witnessing procedure that they followed with arrest and search warrants?
They will be, rarely, but there has been situations where they are. The not uncommon is where there's an extension of a detention period under the Police Powers and Responsibilities Act, which a JP can, in fact, receive an application for. And I'm aware of an incident where the JP was, in fact, called in those circumstances because of the issue as to whether there was true consent to that extension, whether the person had been consulted. And indeed, in that case, the justice had, in fact, and had notes of consulting with the person in custody, and was able to say that that had taken place, which was a requirement of an extension of a detention order.
So that highlights the fact that we should keep accurate records.
That's right, because they could say, yes, no, I did, here's my, I did actually check whether they were objecting or whether they wanted the opportunity to seek legal advice. Sure. and they'd signed it, because I know, particularly in regional areas, just where there's not easy access to a magistrate, a justice of the peace may well be approached to extend a detention period for questioning.
Okay, I have no more questions there, but I noticed that there's a couple of questions in the chat line and Q&A line. So, Wendy, do you want to answer some of those questions, or raise some of those questions?
Sure, yeah. Thank you, Brooke. I've been coughing away while you're chatting, so you've been able to miss out on that being included on the recording. So Damien has asked Judge Brassington, do you prefer Zoom or Teams?
Teams. I don't know Zoom very well, so the courts use Teams largely. I don't, when we went through COVID, we were a bit, so I think our systems are based on Microsoft, so we're generally on Teams.
Oh, okay, yeah, because it's a bit like Android and Apple, isn't it? It's like put and hold, yeah.
Well, you've adapted to Zoom quite well.
Yeah, no, it's pretty good actually. Yeah, we do a lot on Teams.
Okay.
And Damien has also asked about coercion to withdraw. So I'm not sure what he means by coercion to withdraw. Is that coercion to, I guess that's coercion to withdraw a complaint? Not,
certainly there's issues with sometimes withdrawal of the domestic and family violence application. They can be withdrawn. There's a form to withdraw, and they may well be something witnessed. There may be, not quite sure if it's withdrawing that sort of document, but again, it's that verification of identity, and if there is concern about someone being coerced, the exercise of the discretion not to witnesses. It's a really, I imagine it's quite a difficult situation for people to face. And I'm not quite sure if that's what he's getting at. Because my recollection is, and I haven't got the form in front of me, but I didn't think an application to withdraw a domestic and family violence order, you know, the form had to be witnessed by a JP. Whether that's the particular form he's referring to.
Okay, I'll ask this one because I think Wendy's coughing is going to get the better of it.
But I'll just check.
There's another question here. What's the most often seen issues with executed documents faced by the courts leading to procedural issues?
Sometimes writing, just the writing of the the date and time, and some people do it it can be quite quickly, so it can be actually difficult to read on the face of the document. And I mean dates, places and time, which seems extraordinary, but that is actually quite a common issue. The other is the wrong date. Again, surprisingly common as an issue. The that really is the major issues, and the challenge to the grounds in search warrants would be the biggest issue we see, that there weren't reasonable grounds.
Right. Yeah. But that's a different thing. That's
a different thing. But for witnessing documents, it's actually legibility is number one, I'd have to say. Yeah. There are arguments that it shouldn't be admitted because it's not clear on the face of it and what happened, the date and that sort of issue. That's probably the major issue, and the accuracy of the document, in the sense the accuracy of the witnessing of the material to ensure that.
Okay, there's another question here. How can JPs and CDECs support the courts to reduce I can't say the word, invalidity of sworn documents? I'm not too sure what they mean by that.
The identity of the document?
Well, they've got invalidity.
Invalidity.
Yeah, I don't know the answer.
No, yeah, the major one is, as I said, no one can know all of the different types of legislative schemes. There's so many, and that difference between justices witnessing matters and commissioners of declarations could always get advice from the JP branch, or I think they keep a register of legislation, and to seek, if there is a doubt, check, because particularly with the different witnessing for commissioners of declaration and justices of peace, that will be an invalid document. Of course, it can't be rectified if it's not sworn by the right person. Particularly it comes up in peace, and, as I've indicated, peace and good behaviour, mainly, that if you have a doubt, then check.
Yep.
With an more experienced JP might be able to assist, or the JP branch.
There's another question here. Are there often issues with mistakes on police documents?
There are. That's not about any other issue, but sometimes the only argument that will be is in court is going to be whether you admit the evidence or not. Obviously, if the evidence, so people will focus on the documents because of the critical importance of the evidence that was sourced through the document. So, so there's a lot of, on police documents in particular, there's a lot of concentration. There's a lot of scrutiny of those matters simply because of the importance of the document, and they're the ones that are most usually considered by the courts because of the importance of them. So yes, complaints, search warrants, and when I say complaints, I mean complaints and summonses which are completed by justices, are the subject of intense scrutiny because of their importance. You know, even a simple complaint of an offence and the issue of a summons with a minor discrepancy can give rise to arguments about the complaint being a nullity, can't be amended, it should be struck out. And because of limitation periods, then no further charges can be brought. So those matters often give rise to significant disputation.
There's another question here. Have any issues or examples arisen where a JP has not properly considered the human rights legislation in signing a warrant, where a subject of a warrant asserts their rights were breached?
Not that I'm aware of. I suspect there will be, but the Human Rights Act is, you know, how it's structured is there's all of the human rights. A breach of those human rights is not something that gives rise in a court to a power to exclude. It gives rise to a power to go to the Supreme Court and seek a declaration that that legislative scheme is in breach of a human right, but that itself doesn't strike it down. So the Human Rights Act is used largely when we're looking at something as interpretation of a statute to say that you know, if there is an argument about an interpretation, one that favours the upholding a human right is to be preferred. So, but that's not to say some of the human rights are of course competing. You know, the right to privacy as opposed to the right to safety, some of those competing rights. So I haven't heard that argument, but I'm not ruling it out.
But I guess another way of looking at that too, of course, is that it means that the JP or the witness is getting too involved, even to the point where they may be giving advice. That's
right. You do, as I said, the role is, yes, you don't have to be to witness a document. You don't have to be satisfied. You know, that's not the test for, say, witnessing a document that allows a search warrant. The test is a reasonable ground to suspect. So it's always to get the test that you're doing in your own head right.
Okay, another one here. As courts and court processes become congested, do you see the roles of the JPs and CDACs changing or becoming more onerous, taking on more responsibility?
It's an interesting question. We are in the midst, and I think it's just about to be delivered, of probably the most significant change for over 150 years, which is the New Justices Act. Michael Shanahan, who's a retired district court judge, is delivering a report to the Attorney General about a new Criminal Procedure Act. And that act will revolutionise the Magistrates Court because it will look at all of our procedures, and anyone who's looked at the Justices Act will be aware of the different, you know, what justices of the peace, Magistrates Court can and can't do in court, including from adjournments and sitting in remote areas and indeed hearing matters with 2 JPs and bail applications. So into the future, that report by Mr. Shanahan and the legislation that may well come from that, may give us some guidance into the roles into the future and the roles of the courts, they're ever demanding in the complexity of the work sometimes that's coming through is very different to even when it began as a magistrate in 2005, and it's been very significant changes in that time, and I suspect we'll see more. Whether there is scope for diversion and diverting people out of the court system, and I know that JP Branch has worked particularly in remote areas for JP courts. There have been not issues, it's difficult for people who sit in the community and also sit as JPs in a court, and that's been, I think, an issue for people. So I suspect that question will be answered by the report that will be due. Well, we haven't seen it, obviously, but I understand it's to be presented to the Attorney General next week. So
watch this space.
It's very much watch this space. The future is, as I said, going to be, I think, very much dictated by that those changes, and to see a new Justices Act since first one since 1886 will be quite an experience for all of us.
Yeah. Okay, there's another one here. Given the changes in special witnesses for documents, has this caused issues or alleviated issues that were present previously for the court, such as warrants, bail affidavits and criminal proceedings? But I didn't think special witnesses were doing those.
No, the special witnesses are a very isolated group. I suspect, and this is just a speculation, that over time the issues of audio-visual witnessing will be sort of removed. It would become more common, and there may be some changes with that. The signing under substitute signatories and that is a much more complex scheme, and that may well continue where it's done remotely with special witnesses. But what a special witness does is witness over audio-visual link, and that's confined to that. And with only 28, it seems quite a small, with all of the work that you do.
There's not a lot there.
No, so I wonder if, as we become more used to technology, and this happens in certainly in a lot of our Evidence Act, which began very strictly for, say, receiving computer evidence, incredibly strictly, when there were hardly any computers. So they had to have all this proof. And now, I mean, we receive computer generated documents, all the time without that level of complexity. So I suspect as we evolve with like Zoom and it becomes more common, the scheme itself will probably become less complex.
Sure.
A bit like receiving computer documents has in the courts and a lot of that sort of evidence.
Okay, there's another one here. Given the powers of JPs and the congestion of the court, particularly in the summary jurisdiction, has any thought been given to engaging JPs in that capacity to alleviate workloads of sitting magistrates and efficiency of court proceedings?
Because of the limitations of the jurisdiction is probably the issue, largely. And the rise of video technology, video, audio, visual link once, I think JPs doing bail in remote communities was much more common, particularly in working in courthouses, but sitting and doing bail. And indeed, when I started, it was quite common for justices to sit and consider bail applications. But as we've become, as we've got so much more video technology now, we tend to be able to do remote a lot of remote work without a magistrate in the area by video. When we sat at the Cape, I sat in Cairns, and we used to do bail across the Cape for people in. So there is an issue as to, and this is one of the issues we face, as to the training and indeed the complexity of the law. It's our summary jurisdiction is becoming more complex. The issues with those matters are really policy issues more than I can comment on.
Okay, we're getting close to time, so but there's a couple more here. Do they continue to appoint category JP magistrates with court staff? So obviously, are there JP mag courts being appointed?
Yes. I assume, if you're employed in the Department of Justice as a clerk in our registries, they're Commissioner of Declarations, and certainly aware that many of our registry staff, and indeed in my office of the Chief Magistrate, I have administrative officers who are doing their JP qualified and JP Magistrate courts exams. So yes, in the courts, it's still extremely common.
Okay, we might just have one more, if that's okay. Are you aware of how the QCAT JP trials are going?
I am aware of the Townsville trial, and we thought it was wonderful, can I say? Because outside of Brisbane, QCAT is done by magistrates, and it's a significantly busy area, minor civil disputes, I should say, and that includes residential tenancies, debts. And I know there was JP trial in Townsville, and in fact, I was talking to the regional coordinating magistrate up there who was asking me, which I have to further investigate, because it sort of because of COVID closed down, and he was very eager to find out it would be if it was recommencing. So that is on my to-do list, because we found it particularly in Townsville of significant relief for magistrates.
Okay. Judge, on behalf of the organisation, the association, I'd really like to thank you for the time that you spent with us tonight, and your presentation, and also answering some of those questions, or answering the questions as well. So much appreciated. Thank you.
Oh, right. Thank you for having me. I hope it's been useful. And again, I'd like to just thank everyone for their work. It's immensely helpful, really helpful.
Thank you.
Thank you. I'll press my leave button.
Thank you. Thank you. And thanks to everyone for attending Connect Session 2 of 2023. Don't forget that at the end, you will receive a survey. The survey helps us to build our Connect sessions. The next session is on the 22nd of June, and we'll go into the member resources, and hopefully I'll have a proper voice by then. And the following one, which is in August, I believe, we don't have a topic yet. So by all means, if you think of a really good topic that we could have on Connect, then email me at admin@qja.com.au, and we'll certainly try to fit it in. We will send you a link to the recording. I thought that was a great session and very, very informative. And I'll just pull a plug for our logbooks. We still have them. And of course, the QJA e-logbook. As you heard, they are quite important at the end of the day. So again, good night, and I hope you enjoyed the session and got a lot out of it. So thank you, everyone, and especially thank you to Brooke for taking over. I think that you would have had a lot of coughing on that recording if you hadn't. So thanks again, and good night.
Good night.